What's good, babes? Welcome back to Black Tea. It's your girl Ebony. So this will be a shorter version of my life from earlier explaining why Nicki Minaj is requesting not only a meeting with the judge, but to also have this frivolous lawsuit thrown out and dismissed altogether. Now you guys know I did go live earlier and that was extremely long because we went over all 27 pages. But in this video, we are just addressing what Nicki Minaj is pointing out to give you guys a shorter version. So I hope you guys enjoy this video. Now back to the tea. So to begin, the way that this response is laid out is actually in an email to the presiding judge, Judge Vitellano. And this is what Nicki Minaj's lawyer starts with. So the first reason Nicki's lawyer believes that this case does need to be dismissed is because of the right of venue. So what does that mean? Usually, when you have a case, especially a tort case, you have to make sure that you are filing in the proper venue, meaning you are filing where the claims you say happened against you took place. Now, this is standard legal procedure, and most lawyers do understand that rule. Now, Nicki Minaj's lawyer says this: the amended complaint should be dismissed pursuant to Rule 12b-3. In first instance, the plaintiff, Jennifer Hough, has not met her burden because the amended complaint does not allege any basis for venue in this district, instead stating only that the plaintiff, Jennifer Hough, felt the bulk of the defendant's actions were in the states of Georgia and New York. This allegation does not support venue because it requires that events took place in the relevant district. Turning then to the alleged events in the case, the plaintiff, Jennifer Hough, is undoubtedly resting her venue claim upon the fact that the attempted R-word for which the defendant's husband was convicted occurred in Queens County. However, the location of that event is irrelevant to the issue of whether venue as to the defendant is proper, because when venue is challenged by a defendant, the plaintiff bears the burden of proving that the venue is proper in the forum state for each claim against the defendant. Nicki's lawyer says, given the page limit for this letter, I cannot detail each of the amended complaint's minimal allegations against the defendant, Nicki Minaj, but they can be found at paragraphs 82, 84 through 85, 88 through 94, and 100 through 4. Not a single one of these allegations even remotely suggest any conduct in New York. The lack of connection between these allegations and the Eastern District of New York is further demonstrated by the fact that the three claims of relief asserted against the defendant, Nicki Minaj, in the amended complaint all seek relief under California and Georgia law. If the plaintiff were alleging that the defendant engaged in any conduct in New York, she would have also sought relief under New York law. So this is very important, and you guys know that I did explain an anti-SLAPP law, and that was my understanding of why this was filed in New York. So Nicki's lawyer is saying, in order for you to basically sue Nicki Minaj, you have to prove that some of her conduct happened in New York. If it did not happen in New York, then you need to seek relief under California and Georgia law. Now in section B, this is what Nicki Minaj's lawyer says. The second reason why this case should be dismissed is because the complaint should be dismissed pursuant to Rule 12b-5, which is the proper rule of service. So once a defendant actually moves to dismiss under this rule, this is basically saying that the plaintiff bears the proof that they provided adequate service to Nicki Minaj. Now in the affidavit of service from Jennifer Hough and her attorney, they actually stated stated that the defendant was served via personal service. A copy of the summons has been attached to the complaint for the court. The defendant, Nicki Minaj, however, is saying that in a declarated sworn statement that she and her husband were not actually served, and the person that the process server basically alleged was the person that gave the paperwork to the Pettys did not reside at that home. So again, the second reason they feel that this case should be dismissed is because Nicki is saying that she was not served properly. Now, Nicki actually cites the actual process server. According to the process server, there was a man who was 40 years old, 200 pounds, black male, who he or she gave the paperwork to. There was no picture taking from my understanding. There was also no recording proving that this person was Kenneth Petty. Nicki's lawyer says the defendant has actually executed a sworn statement believing that the process server was not honest about who was served at the residence. Therefore, this is the second reason why this lawsuit should be thrown out. Now, number 3, this is actually the complaint should be dismissed pursuant to Rule 12b-6. Now, what does this mean? Nicki's lawyer is saying the 3 claims for relief asserted against Nicki Minaj are almost unintelligible and certainly not sufficient to withstand a motion for dismissal. So he's basically saying that the lawsuit doesn't even make any sense. It's frivolous. And on top of that, there is no way you expect to get any monetary benefit from the claims you have laid out in this lawsuit. For example, Nicki's lawyer says Count 5 alleges that the defendant, Nicki Minaj, engaged in harassment under California and Georgia law. This claim under California law is facially frivolous because plaintiff is seeking damages for violation of California Civil Process Code 527-6. For those of you guys who don't know, California Civil Process Code actually deals with restraining orders, and it actually helps those people who cannot get any help get some protection from the alleged person who is stalking them or intimidating them. Nicki's lawyer goes on to say this: as drafted then, the amended complaint failed to state a claim for harassment and witness intimidation because it does not even identify a claim pursuant to which a plaintiff can seek damages. Because it is hard to imagine that the meager allegations against Nicki Minaj in the amended complaint would provide factual content, allows the court to draw the reasonable inference that the defendant is liable. In the next count of the amended complaint, it actually alleges that the defendant is liable for also aiding and abetting under California and Georgia law. This claim is incomprehensible because the claim that a defendant was aiding and abetting another person is meaningless unless the plaintiff also identifies the underlying conduct which was supposedly being aided and abetted. Here, the amended complaint fails to do so. The amended complaint alleges that Nicki Minaj should be held liable under California and Georgia law for intentional infliction of emotional distress. The allegations against the defendant in the amended complaint do not remotely make out the elements of that tort under either California or Georgia law. See Bellin v. Ryan and also some other cases that were cited. Respectfully yours, Judd Bernstein. So as you see here, he pretty much laid out his reasoning for why this case needs to be dismissed. The first reason was the fact that this case was filed in the wrong venue. We understand that in order for a civil case to be proper, it has to be filed in the proper venue. If you are seeking damages for things that happened in California and Georgia, then why are you filing in New York unless you're trying to avoid an anti-SLAPP law? The second thing is proper rule of service. If Jennifer Hough and her attorney did not take a picture or did not get any proof that Kenneth Petty was the person who was served, this means that Nicki Minaj was not properly served. Therefore, this case should be dismissed. dismissed and any type of default judgment should be set aside. The next thing, you are requesting relief for an incident that does not require any monetary damages or relief from Nicki Minaj. Nicki Minaj was 12 years old at the time this incident back in 1994 occurred. Therefore, Nicki Minaj is not indebted to you as a reasonable citizen and a minor at the time to basically pay you for something that happened to you between you and Mr. Petty, allegedly. On top of that, Nicki's lawyers actually point out something very good in their memorandum, and they say this case is founded upon the defendant's husband's 1995 conviction for an attempted R-word that occurred 27 years ago. The amended complaint does not allege that the defendant, who was only 12 years old at the time and now is a hugely successful and famous recording artist, had any involvement in that underlying conduct. Rather, it alleges that she only engaged in non-actionable conduct, alleging commencing in 2018 in response to plaintiff Jennifer Hough's demands for money. As against defendant, the amended complaint is just the next stage of the plaintiff's efforts to extract money from defendant arising out of conduct in which she had no involvement. It is frivolous, amalgam of implausible and illogical factual allegations, unsuccessfully searching for a cognizable legal theory. In truth, the defendant has been sued for two reasons, neither of which are tied to the merits. First, as evidence of fact by the plaintiff did not seek damages for harm suffered in 1994 until after the defendant publicly married her husband in 2019. Defendant has been sued because she is proverbial deep pocket. Second, the plaintiff's counsel, Mr. Blackburn, has named her as a defendant in an effort to garner media attention for himself. Jennifer Hough's lawyer and his motives are well demonstrated by the fact that due to the plaintiff's counsel pursuit of media attention, the defendant has been forced to bring a motion concerning a dispute which should have been resolved by counsel without the court's intervention. On October 11th, just 5 days after the date by which the defendant would have been required to respond to the amended complaint if she had been properly served. If she had been properly served, the plaintiff's lawyer filed a request for a certificate of default from the clerk of the court. Just 2 days later, on October 13th, the defendant's counsel sent plaintiff's counsel an email asking him to withdraw his request for a certificate of default, and instead of agreeing to an extension by time of just November 1st for the defendant to answer or move against the amended complaint, the plaintiff's lawyer, Mr. Blackburn, responded as follows: "You can file your opposition and explain to the court why your client believes that her and her husband are above the law. I do not consent to an extension." But for what happened next? The plaintiff's lawyer, Mr. Blackburn, refusal to make a reasonable accommodation might have been excused as genuine, albeit erroneous assumption that the only relevant question for the court to decide. However, subsequent events show that the plaintiff's lawyer, Mr. Blackburn, refused to agree to the defendant's counsel request because he wanted to use it as an excuse to secure a media article for himself. Hence, the next day on October 14th, the Daily Beast posted an article about which plaintiff's counsel surely planted. Now, as you guys see on the screen, this is the article from the Daily Beast. Now, Nicki's lawyer says obviously the plaintiff's lawyer had a right to seek out press coverage, but that does not change the fact that he is burdening the court with unnecessary motion practice just so that he can secure some cheap and transitory media attention. Ooh, yeah, not cheap. Ooh, yeah. This lawyer then got them all together. The facts relevant to determination of this motion are set forth in both the Bernstein December and the accompanying declaration. So there you guys have it. You know, Nicki Minaj's lawyer did a great job of pointing out the reasons he feels that this case should be dismissed. I also find it very, very interesting that they decided to really just attack the lawyer. And I also think that that goes to a testament of Nicki Minaj not wanting wanting to attack Jennifer. This isn't about Jennifer. This is about people using Jennifer in her story to garner their own self-clout. And I hope you guys enjoyed this shorter version of the legal documents. And I wanted to give you guys something that was more concise so you guys know the reasons why this case should be thrown out. This was not filed in the right venue. If you want to file a case, you have to file a case where the incident took place. And number 3, the information based on the plaintiff, Jennifer Hough's own story, is for restitution. Nicki Minaj was 12 years old when this happened to Jennifer, so she is not indebted to Jennifer for restitution. And I also think it's a fair statement to say that Jennifer would not be suing Kenneth Petty if he wasn't with deep pockets, as Nicki's lawyer said, Nicki Minaj. So I hope you guys enjoyed this breakdown. Leave a comment down below. Let me know what you think about this response, and how do you think this case is going to pan out? Do you think it'll be dismissed? And what are your thoughts on Jennifer's lawyer running to the media so much? Do you think it's a bad idea? Let me know down below. Don't forget to subscribe to the channel. I love you guys so much, and we'll talk soon. Bye, babes.